If you think your immigration case is safe, think again. USCIS just pushed out the biggest wave of changes we've seen in years, and some of them take effect before January. These updates could pause your work permit, delay your green card, or even cancel your eligibility overnight. Most people have no idea what's coming, but after the next few minutes, you will. Because if you miss even one of these 10 updates, your entire immigration journey could be at risk. The first major update is the end of automatic work permit extensions. For years, workers could rely on an automatic extension while their EAD renewals were being processed. That extension used to give applicants extra months of breathing room whenever processing times became long and unpredictable. That safety net has been removed. Now when someone applies to renew a work permit, they do not get that extended grace period. If the renewal does not get approved by the expiration date on the current card, the applicant may simply lose work authorization until USCIS finishes processing the application. Imagine waiting months and suddenly being told you must stop working immediately because your card passed its expiration date. That is why anyone with a work permit expiring soon has to plan ahead, check current processing times, and submit renewals as early as possible. The second update is the change to how a child's age is calculated under the Child Status Protection Act. Many families have relied on this provision so that children would not lose eligibility for immigration benefits when they crossed the age threshold of 21 while a petition was pending. A more generous interpretation allowed many young adults to stay protected, but USCIS has now returned to a stricter method. This means thousands of families may experience unexpected age outs, and a child who was on track to immigrate with parents might suddenly need an entirely new petition. Age calculations now require precision and planning. Families need to check their priority dates, understand how the new calculation works, and prepare alternative plans if a child is close to turning 21. The third update affects anyone preparing to file any immigration form. USCIS is moving fully into electronic payment systems and is no longer accepting traditional paper checks or money orders. It may sound minor, but this change has already led to rejections for people who did not realize the rule had shifted. A rejected application can cost weeks or even months of delay, and in some cases may cause someone to fall out of status entirely. The best approach now is to double-check acceptable payment methods each time you file, especially if you use older printed instructions or rely on advice from friends who applied years ago. Immigration rules change constantly, and this is one of those changes that can sneak up on you. The fourth update is one many employers and employees are still trying to process. Certain employment-based visa categories, including the widely used H-1B, now require a new proclamation fee. This dramatic increase has already created shockwaves in the business community. Smaller companies may decide to avoid petitioning altogether because of the cost. Some employers will shift hiring overseas rather than pay the significantly higher fee. For immigrants already in the United States on work visas, this could impact long-term career planning. If your employer budgets immigration costs annually, this new fee may require new approvals, new conversations, or even adjustments to your job plans for the new year. Anyone relying on an employment-based petition should check with their employer now rather than waiting and hoping everything is still the same. A major fifth update involves a transformation in USCIS itself. For years, USCIS was known primarily as an administrative agency that reviewed forms, made decisions, and processed immigration benefits. Now the agency has expanded law enforcement capabilities. Officers can conduct investigations, carry weapons, execute warrants, and work more closely with other enforcement agencies. This shift means immigration applications may face deeper scrutiny. Small mistakes or inconsistencies that might once have been seen as harmless clerical issues may now raise red flags. The message for applicants is clear. Review every document, avoid contradictions across different filings, and keep copies of everything you submit. Precision and transparency are more important than ever. The sixth update concerns naturalization and the process of becoming a United States citizen. The definition of good moral character has expanded, and this affects who qualifies for citizenship. Officers reviewing naturalization applications now have broader authority to examine personal backgrounds, history, conduct, and even digital footprints. Past behavior, even behavior unrelated to immigration status, could now be considered during review. People applying for citizenship should take this change seriously. It is no longer just about paying taxes, following the law, and meeting the residency requirements. It is about demonstrating stable, consistent behavior in all areas of life. The 7th update involves the naturalization civics test. A revamped version of the test has been introduced, and applicants now face different question structures, revised study materials, and possibly higher expectations for demonstrating knowledge of United States history and government. Anyone planning to apply for citizenship in the upcoming months should prepare early. Do not rely on old study guides or outdated online practice quizzes. This is one of those changes where early preparation could be the difference between passing and failing. Next is the 8th update involving special naturalization provisions for former service members. Under earlier interpretations, some veterans with uncharacterized discharges could still qualify for naturalization under military service-based sections of immigration law. This has changed. USCIS no longer treats uncharacterized discharges as having been issued under honorable conditions. Veterans who believed their service made them eligible may now find they are not. Anyone in this category should speak with a qualified immigration advisor and obtain documentation showing the nature of their service before beginning the naturalization process. The 9th update has to do with changes to asylum-related customer service procedures and confidentiality practices. While the details can be complex, the simplest explanation is this. Some of the protections that had previously structured how USCIS interacted with certain vulnerable groups have been revised. Applicants who rely on privacy protections or special handling should be aware that the environment has changed. This may affect communication with USCIS, how cases are processed, and what information the agency may share or request. Finally, the 10th update is not a rule but a reality. The backlogs across USCIS remain extremely large. With the removal of automatic work permit extensions, stricter age calculations, higher fees, increased scrutiny, and new officer authority, processing delays may continue to grow. Applications are not only moving slowly, they are also facing closer review. That combination means more people may experience unexpected denials, requests for evidence, or long stretches with no decision. This is why preparation has never been more important. Submitting a complete, well-organized application with strong supporting evidence is the best way to protect yourself in an unpredictable environment. All of these changes combined create a very different landscape for immigrants heading into the new year. The people who succeed will be the people who prepare. Start early. Double-check every rule before submitting anything. Track your expiration dates. Make digital copies of your documents. If you are unsure about something, get help rather than guessing. Immigration rules are complicated on a good day, and during a period of rapid change they can trip you up easily.